content with a parade of prison officers and police ready and awaiting your inspection, sir.
And welcome. Today this court has been convened in this annual special sitting of the court to mark the new law year. Let me begin by first welcoming all of you back. This is the first such sitting since the unfortunate and calamitous events of September 2017, and as you can see, our bench looks vastly different from our last sitting. So I would first like to take this opportunity to welcome my colleagues. Justice Adderley, who sits in the Commercial Division. Justice Adderley actually joined us in September 2017. And since then, he has rendered yeoman service in very difficult circumstances. There will be more said on that a little later. Justice Adderley has graciously agreed to remain with us for a period of 1 year, with effect from the 1st of September 2018. He is assisted in this by our brother, Justice Wallbank. Justice Wallbank is no stranger to any of us. He actually has sat here as a judge on and off since 2012, and we are indeed very grateful for that fact, and for the fact that he will be with us for a further period of 3 months, commencing the 6th of October to the 14th of December 2018. Also familiar to many of you would be Justice Smith. Justice Smith has returned to the BVI to head our criminal division. She has been at the reins since the 15th of February of this year, and we extend a warm welcome to her as well. To all of you, I say a hearty welcome. You will no doubt find the work challenging, but fortunately in the BVI, we have a very competent, cooperative, and supportive bar. And when combined with the capable, hardworking court and registry staff, this should make your burden, if not a little lighter, then certainly more rewarding and more enjoyable. On behalf of the Honorable Chief Justice, I wish to express our deep appreciation for your willingness to serve on this bench, and I pray that God will continue to strengthen and bless each and every one of you. Sadly, as we welcome new jurists, we also have to say a fond farewell to others. Shortly after the passage of Hurricanes Irma and Maria in September 2017, Justice Bayer was temporarily assigned to the St. Vincent Circuit. This assignment later became permanent, and BVI's loss became St. Vincent's gain. In addition, Justice Leon also left our court in March of this year. Justice Leon, as you know, headed our commercial division for the last 3 years. In the wake of the 2017 storms, and for a number of logistical reasons since then, we did not have an opportunity to formally express our gratitude for their service and to say farewell in the usual special sitting. So on behalf of everyone here, and on my own behalf, I would like to express our deep appreciation for their years of service. We thank them for their outstanding contributions in the execution of their duties, and we wish them every success as they go on to fill their respective legal destinies. As shown on your printed program, and I hope that we all have a copy. We will begin with the Honorable Chief Justice's address, which is being delivered today from St. Kitts to all the jurisdictions of the Eastern Caribbean Supreme Court. Her theme this year, Challenges, Opportunities, and Resilience, the ECSC paving the way to a modern and efficient judiciary in the Eastern Caribbean. I invite you all to join us in listening to the Honorable Chief Justice's address, which is due to begin in a few minutes.
Honorable Chief Justice, Dame Janice M. Pereira, Honorable Justices of Appeal, Honorable High Court Judges, Honorable Vincent Byron, Attorney General, Senior Magistrate and Magistrates, Mr. Volston Graham, Director of Public Prosecutions, Ms. Simone Bullen Thompson, Solicitor General, Ms. Michelle John Thibbles, Chief Registrar, Eastern Caribbean Supreme Court, Ms. Janine Harris Lake, Registrar of the High Court, Mr. Thaddeus Antwine, President of the OECS Bar Association, Ms. Delia Rowe Joseph, President of the St. Kitts and Nevis Bar Association, learned members of the Inner Bar, learned members of the Outer Bar, members of the Diplomatic Corps, Mr. Michael Morton, Honorary Consul, members of the clergy, Mr. Ian Quealy, Commissioner of Police, Lieutenant Colonel Anthony Cumry, Commander of the St. Kitts Nevis Defense Force, Mr. Sheila Connor, Superintendent of Prisons, Mr. Ian Francis, Permanent Secretary in the Ministry of Justice, Mr. Everett Ogaro, Fire and Rescue Services, distinguished guests, good morning. It is my distinct pleasure on behalf of the resident judges in the Federation of St. Christopher and Nevis to welcome all of you to this special sitting of the court to mark the commencement of the new law year 2018-2019. Last year, nature denied us the opportunity to play host to this auspicious event, as we recall all too well the havoc that was wreaked by the passage of Hurricanes Irma and Maria through several of our member states. The ceremonial opening had to be canceled as priority naturally shifted to the task of recovery and reconstruction, and indeed, their survival. The last couple of weeks perhaps produced some anxious moments, as it seemed that a similar threat loomed once more. But God, in his infinite goodness and grace, spared us all and blessed us with radiant sunshine, which has made it possible for us to gather here today. Our theme this year, Challenges, Opportunities, and Resilience, the Eastern Caribbean Supreme Court paving the way to a modern and efficient judiciary for the Eastern Caribbean. The first challenge, I submit, has been successfully hurdled. Appropriately, therefore, we commenced the day's proceedings with an inspirational and uplifting ecumenical church service at the Zion Moravian Church, culminating with Father Cassius's insightful and interpretive perspective on our chosen theme. Fortified by the blessings received, we set out on a wonderful procession in the sweltering heat, appropriately clad in our black robes. As I made my way along the procession, sweating profusely, the words of Dr. Henry Brown, Queen's Counsel, came to mind, and he would say, "This is a hard way to make a living." But we soldiered on. We look forward to the year ahead, mindful of the inevitable challenges that will confront us along the way, poised to seize the opportunities that arise, and resolved to effect the transformation of the judiciary in realization of our shared vision for a futuristic court. This we can accomplish by all stakeholders working harmoniously together. I look forward to that continued collaboration. At this stage of the proceedings, it is my pleasure to yield to the Honorable Chief Justice, Her Ladyship Dame Janice Pereira, who will deliver the opening address to be carried live to the other member states and territories throughout the region. May it please.
Thank you, Justice Ward. Justices of Appeal, judges and masters of the Eastern Caribbean Supreme Court, their excellencies, heads of state of each of the OECS member states and territories, the Honorable Timothy Harris, Prime Minister of St. Kitts and Nevis, and honorable heads of government of each of the OECS member states and territories, retired judges of the Eastern Caribbean Supreme Court, the Honorable Vincent Byron, Attorney General of St. Kitts and Nevis, and Honorable Attorneys General of each of the OECS member states and territories, Honorable Ministers of Government of St. Kitts and Nevis and of each of the OECS member states and territories, Chief or Senior Magistrates and Magistrates of each of the OECS member states and territories, Honorable Speakers of the Houses of Assembly and Presidents of the Senate of each of the OECS member states and territories, Honorable Leaders of the Opposition of each of the OECS member states and territories, Members of Parliament of each of the OECS member states and territories, Dr. Didicus Jules, Director General of the OECS Commission, Mr. Valston Graham, Director of Public Prosecutions of St. Kitts and Nevis, and Directors of Public Prosecutions of each of the OECS member states and territories, Solicitors General of each of the OECS member states and territories, Mrs. Michelle John Thibbles, Chief Registrar, Ms. Desma Charles, Deputy Chief Registrar, Registrars and Deputy and Assistant Registrars of the Eastern Caribbean Supreme Court, Mr. Gregory Gerard, Court Administrator of the Court's Headquarters, Mr. Francis Letang, Deputy Court Administrator of the Court's Headquarters, Mr. Thaddeus Antoine, President of the OECS Bar Association, President of the Bar Association of St. Kitts and Nevis, and Presidents of the constituent bar associations of each of the OECS member states and territories, learned members of the Inner Bar of each of the OECS member states and territories, learned members of the Outer Bar in St. Kitts and Nevis and of each of the OECS member states and territories, members of the clergy, members of the diplomatic corps, Mr. Ian Quealy, Commissioner of Police of St. Kitts and Nevis, and Commissioners of Police of each of the OECS member states and territories, police officers in St. Kitts and Nevis and each of the OECS member states and territories, Mr. Ashiel Connor, Acting Superintendent of Prisons in St. Kitts and Nevis, and other directors, heads of correctional facilities in each of the OECS member states and territories, staff of the Court's Headquarters, and the various court offices in each of the OECS member states and territories, distinguished guests, students, citizens and residents of the Eastern Caribbean, good morning. It is my honor and indeed my pleasure to address you on this occasion of the opening of the 2018-2019 law year. Today's address is being broadcast live via simulcast from the Federation of St. Kitts and Nevis to all the other 8 member states and territories of the Eastern Caribbean Supreme Court, where special sittings are also taking place. Persons across the region and indeed the world are also listening in to this address on the radio and via the internet. The Federation of St. Kitts and Nevis celebrates tomorrow its 35th year of independence I extend to the government and people of the Federation heartiest congratulations on the occasion of this anniversary. This year's address holds particular significance as it has now been 2 years since I have had the opportunity to address you on the commencement of a new law year. As many of you would know, last year's activities to mark the opening of the 2017-2018 law year were to take place on the Nature Isle of the Commonwealth of Dominica. Hurricane Maria intervened, bringing all activities to an abrupt halt. All sittings of the court had to be vacated. This storm caused much death and destruction in Dominica and occurred a mere 2 weeks after Hurricane Irma caused death and widespread destruction along the northern Caribbean island chain, including the territories of Anguilla, the Virgin Islands, and the island of Barbuda. These Category 5 hurricanes set new records in terms of their intensity and will not soon be forgotten by the people of the Caribbean. 1 year on, some level of normalcy has returned to these islands, but the effects linger on. As we sit here today, we are no doubt all aware that we are in the height of the hurricane season. We had a narrow miss with Isaac last week. It is my fervent hope and prayer that our Caribbean region will be spared the ravages of any more storms this year. I want to dwell a bit on the impacts of the hurricane season last year, because these hurricanes severely impacted normal governmental operations across the affected islands, and without exception, the operations of the judiciary. I will therefore use the first part of this address to briefly share with you the impact on the court's operations and to provide an update on where matters stand today. The island of Anguilla. The eye wall of Hurricane Irma, passed over the territory of Anguilla on 6 September 2018, causing widespread destruction. The court building, as well as the residence of the High Court judge, received some damage. The court facility was forced to remain closed for several weeks whilst repairs were made and utility services restored. This physical interruption, though, did not prevent the hearing of urgent applications by telephone and video link as soon as telecommunications were restored by the direct routing of hearings to a judge located in St. Lucia. Full appeal hearings were also conducted in person and via video link from St. Lucia. Today, the court's facilities are once more fully functional and were first to resume full operations after the storm. The Virgin Islands. The territory of the Virgin Islands received the brunt of Hurricane Irma as the eye passed directly over Tortola on the 6th of September 2017. It caused a catastrophic damage to the territory, which is still in the process of recovering. Court infrastructure was severely damaged, judges and some court staff were rendered homeless, and all operations of the courts came to a halt. A breakdown of law and order threatened. The state of St. Lucia provided early refuge. One of the immediate measures put in place was the temporary relocation of the commercial division of the High Court, a critical component of that territory's financial sector, to the state of St. Lucia, where the court's headquarters is based. The temporary relocation of the 2 commercial division judges, along with some members of the court staff from the Virgin Islands, the utilization of a rudimentary system of electronic filing via email, the use of other ICT technology put in place by the IT team of the headquarters, complemented by emergency procedural measures and support from staff of the court's headquarters, allowed that division to continue its operations seamlessly. All matters listed for hearing came on as scheduled. Indeed, it was said by many legal practitioners who experienced this temporary e-filing arrangement that the court's processes, by use of this rudimentary method, was operating even more efficiently than the normal paper filings. If there was a need for an argument supporting a paperless judiciary and as the way forward for building resiliency to natural disasters, the experience of the BVI's commercial division made it convincingly. I should also add that during this period, full appeal hearings for the Virgin Islands were held without disruption by means of video link and in-person appearances from courtrooms in St. Lucia. At this juncture, it is only fitting that I pause for a moment to express thanks to the Prime Minister and government of St. Lucia for quickly coming to the aid of the Virgin Islands in facilitating the temporary relocation of the commercial division to St. Lucia during that difficult time. This speaks to the heights which can be achieved and the possibilities which can become realities when there is a will to do so. The commercial division resumed operations in the Virgin Islands in January 2018. The operations of the main civil and criminal divisions, however, took longer to get up and running. This was due to several factors beyond the court's control, such as a greater reliance on physical files, many of which were damaged or lost during the hurricane and requiring reconstruction, as well as the need for the appearance of litigants and witnesses in person, not to mention the risks inherent in the movement of prisoners or accused persons on remand. Notwithstanding these limitations, the court was able to accommodate the hearings of urgent applications, including applications for bail, via video and teleconference, conducted by a judge at court facilities in St. Lucia. All divisions of the High Court became fully operational in the Virgin Islands by the middle of February this year. The Commonwealth of Dominica. Hurricane Maria, which struck Dominica on 18 September 2017, resulted in the almost complete destruction of that island. 1 year on, the island is still struggling to return to some sense of normalcy. The court's infrastructure was severely damaged, with judges and court staff rendered homeless. Here too, a breakdown of law and order threatened. Sadly, 1 year on, court facilities have not been restored to normal operations. Here, there was an even heavier reliance on paper records, and many of them have been reported lost or destroyed. These factors, coupled with a lack of operational facilities, make recovery slower. Some hearings have been facilitated in makeshift facilities while repair works are ongoing. The hearing of appeals from Dominica was also facilitated by the Court of Appeal, sitting in St. Lucia. It is our hope that all efforts will be made to enable the courts to return to full operations. The court's headquarters has been doing all within its power to make this happen and has reached out to donor agencies for assistance in replacing the destroyed court equipment necessary for returning the courts to a state of operational efficiency. International donors, such as Global Affairs Canada, through the Juris Project, executed through the Caribbean Court of Justice, as well as the U.S. Embassy, have responded positively to our request, and the procurement processes to source and purchase replacement equipment are well underway. Assistance is also being sought from the European Union. Quite apart from that, financial and other support was quickly forthcoming from our neighboring institutions, judges, and organizations. I make specific mention of relief funds generously given by judges of the Caribbean Court of Justice, the Caribbean Association of Judicial Officers, the OECS Bar Association and its constituent bar associations across the member states and territories, the judges and staff of the Eastern Caribbean Supreme Court's headquarters. I take this opportunity to publicly thank our regional judicial counterparts, international donor agencies, our court staff, judges, and our regional organizations and associations for their contributions and other assistance to the recovery efforts in our affected member states and territories. Even though the court has suffered setbacks because of these horrific storms, these provided an opportunity for our communities to truly experience firsthand the positively unique character of the Eastern Caribbean Supreme Court and what it truly means to be a regional court. The ease with which the court was able to continue managing, although not optimally, the judicial processes of the affected islands lies within the legislative framework which established the court. It is this framework which allows any judge of the court, irrespective of state or residency assignment, to hear matters from any affected member state in another member state. Arrangements to be made are merely administrative. There was no requirement for legislative or other intervention. The ability of the court to operate in this way must be seen and guarded as a most useful and remarkable utility, being one which allows the court to continue to serve affected states and territories and thereby provide access to justice even in times of disasters. This framework in and of itself should be recognized as a strong foundation on which to build an even more resilient framework for ensuring access to justice by the implementation of systems which can effectively manage and support the court's operations under any adverse condition. Although disasters may cause the court to bow, disasters should never be allowed to cause the court and access to justice to become broken. Out of the depths of adversity, there are always positive and enduring lessons to be learned. It also brings forth that positive human desire to innovate, create, and seize opportunities. It only remains for us, in turn, to turn these desires into positive action in moving forward. In the words of the former First Lady of the United States of America, Michelle Obama, and I quote, "You should never view your challenges as a disadvantage. Instead, it is important for you to understand that your experience facing and overcoming adversity is actually one of your biggest advantages." I am inspired by the sermon I delivered this morning by Father Cassius around the theme of this year's address. He reminded us, tough times don't last. Tough people do. This leads into the second part of my address, and that is to update you on the work of the court over the last perhaps 2 years. Despite the setbacks, the court has been busy pursuing its mission to continue its reform processes aimed at improving the quality of justice. Firstly, I wish to highlight the Eastern Caribbean Supreme Court's Sentencing Guidelines Project, which is well underway. It has long been recognized that for this court to serve the people of the Eastern Caribbean region in an efficient and transparent manner, it must continuously find ways to improve its processes and procedures and embrace systems and methods that are transparent and easily understood by the people it serves. Over time, it became increasingly apparent that the sentencing process in a criminal trial across OECS states was being approached in different ways, with results which to the public appeared to be disparate. Sentencing is one of the areas of great public interest and one which attracts much comment, some of which are often uninformed. In the criminal justice system, the sentencing process is one of utmost importance, as it invariably engages the liberty of the subject. It therefore calls for deliberate and mature consideration in order to ensure that public confidence in the justice system is maintained. The passing of a sentence must not just be done right, but must also be understood as having been done right. It was out of this desire to assist judicial officers, and more importantly, the desire to bring consistency to the approach to sentencing, and in so doing transparency and a greater sense of fairness to the sentencing process, that the idea of a sentencing guidelines project took root. This project began more than a year ago in November 2016, with financial assistance being provided by the joint collaboration between the United Kingdom Foreign Office and the United States of America, with oversight provided by Ms. Sarah Abraham, Criminal Justice Advisor to Barbados and the Eastern Caribbean. By July last year, we had formed a committee of experienced jurists and other experts from within our court, the Caribbean, and the United Kingdom. This committee is called the Sentencing Advisory Committee. It held its inaugural meeting in July last year and has been hard at work since then, crafting draft sentencing guidelines for use by judges and magistrates in our region. The work has focused on rolling out sentencing guidelines in respect of drugs, firearms, theft, robbery, and sexual offenses as the first series of guidelines. Thereafter, we intend to roll out additional guidelines in respect of other offenses, all to be applied in accordance with sentencing principles, which will be set out in a sentencing practice direction to be issued by the court. The first set of these draft guidelines was introduced to all judicial officers at the annual Judicial Conference for Judges over a 3-day period during the last week of July this year, and to magistrates over a 2-day conference following immediately thereafter. The response from all judicial officers has been positive. The Sentencing Guidelines Project and a sampling of the draft guidelines produced to date were also introduced to members of the bar, as well as prosecutors across the OECS region over this past weekend. In fact, yesterday, Sunday, at the joint symposium of the OECS Bar Association and the Eastern Caribbean Supreme Court. Their response has also been encouraging. Thereafter, it is intended that a further consultative process engaging the wider public will be undertaken in each state and territory over the next few months. I place on record my sincere appreciation for all the hard work undertaken so far by all members of the Sentencing Advisory Committee. But I feel I would be remiss were I not to say special thanks to Justice Morley, who serves Antigua and Barbuda and Montserrat as co-chair of this committee and who drives this process, Justice Trevor Ward, our own resident judge of St. Kitts, who serves this circuit, Justice of Appeal Alice York Suhon, appellate judge of the Supreme Court of Trinidad and Tobago, Justice Dame Maura McGowan of the Royal Courts of Justice of the Criminal Division of England and Wales, Justice Shiraz Aziz, a former High Court judge of the Eastern Caribbean Supreme Court, now a judge of the Turks and Caicos Islands, for ably conducting all the training sessions on the draft guidelines at our judicial conferences. Last but no means least, I express my sincere appreciation and thanks to Justice of Appeal Thom, who unfortunately is unable to be here with us today due to circumstances beyond her control, and who is chair of our Judicial Education Institute, because she took this project fully on board and continues to do all within her power to assist me in making the guidelines become a reality. I have no doubt that Justice Thom will be listening once she's able to do so to this address today. Now, the objective of this project is to assist judicial officers in providing structured and well-reasoned sentence remarks as a normal practice and in a format which would encourage their publication. These remarks will build up a bank of authority to assist courts, legal practitioners, students of law, and the public to better understand the sentencing process and in turn promote greater confidence in the criminal justice system. Viewed through the eyes of the public, it is not so much the ultimate sentence arrived at, but rather understanding the reasoning leading to that sentence. The aim of this project is not to achieve uniformity of sentences, but rather consistency in the approach to sentencing, so as to promote fairness and transparency in the process. The second project I wish to highlight is the implementation of a sexual offenses model court. It has been observed over the years that the number of sexual offenses brought before the court has been on the increase. This, of course, does not mean that the commission of sexual offenses has increased. It may be that more sexual offenses are being reported and being prosecuted as gender sensitivity awareness grows across all levels of our societies. It is important, therefore, that the court be equipped to deal with these matters in a way that also addresses the sensitivity of these types of cases, particularly as it relates to the vulnerability of complainants involved, especially children and young persons. After conducting a review, it was considered that the state of Antigua and Barbuda at this time was best suited for the establishment of a sexual offenses model court. The aim of the initiative is to improve the ability of the court to provide more gender-responsive services and to be more focused and understanding of the sensitivity of cases involving victims of sexual offenses. To this end, much work has been underway for the implementation of such a court, and it is the hope that it will be operationalized before the end of this year. This project is being spearheaded by the Judicial Reform and Institutional Strengthening, the JURIS project, as I said before, executed through the Caribbean Court of Justice as the executing regional agency. It is hoped that the successes from this pilot in Antigua and Barbuda will lead to the implementation of similar courts in other member states and territories. I take this opportunity to record my appreciation to all the personnel engaged by jurists in making this model court a reality. Judicial training. Thirdly, the court, through the Judicial Education Institute, continues with its work in providing judicial education for newly appointed judges, as well as for all judicial officers, magistrates, and staff of the court. In addition to the training in relation to the draft sentencing guidelines at the annual judicial conference this year, we also were the beneficiaries of training sponsored by the World Intellectual Property Organization. We are grateful to them for the opportunity this provided to our judicial officers to gain a fuller appreciation of the law relating to intellectual property, and more importantly, for strengthening our capacity to deal with intellectual property disputes, an ever-growing area given the super connectivity of the world and all the opportunities which this presents for proper and improper exploitation. We thank them for partnering with us. I also once more thank the chairman of the Judicial Education Institute, the staff of that institute, and all the other members of staff at the court's headquarters for their tireless efforts in planning and coordinating our education programs. Doing so is by no means a simple task, given our spread across the OECS island states. So far, I have spoken of activities which we were only able to undertake mainly with the kind assistance of the international donors I have mentioned. Judicial reform and judicial education go hand in hand in effecting real change. One cannot succeed without the other. Two sides of the same coin. We are grateful, therefore, for the continued support of those donors. We share a mutual interest, that of improving the quality of justice, which would lead to a more just society. When the people in any country can place the highest confidence in their justice system, it ensures greater peace and security. The ability of any country to enjoy peace and security impacts positively on its economy and its place in the world. In these times, the news is replete, the world news is replete, with the distressing news of failed states, which have been causing the dislocation and migration of entire communities of people, the horrific crimes committed against them, and all the other attendant adverse consequences. Within our region, we must remain vigilant and do all we can to ensure the rights and freedoms which we often take for granted are never diminished, and their vindication by access to justice is not whittled down or rendered illusory. This brings me to the steps which the court has undertaken over the past 2 years to reform various procedures within the court's civil jurisdiction. Firstly, with the cooperation of the bulk of member states and territories, the court was able to implement a more modern and user-friendly set of procedures for dealing with the estates of deceased persons. In 2017, the court implemented the Eastern Caribbean Supreme Court Non-Contentious Probate and Administration of Estates Rules, 2017. The intention of these rules was to harmonize the procedure for non-contentious probate and administration of estates proceedings across the OECS. Formally, different procedures guided the probate and administrative processes in the different member states and territories. Accordingly, for several years, the need for the development of a uniform suite of non-contentious probate rules had been the subject of much discussion in the OECS region. Following a consultancy, a draft set of rules was prepared as early as 2003. However, it was not until 2013 that steps to engage in further consultations with a view to finalizing them were undertaken. Save for 2 states where the process is ongoing for their implementation, all other states have brought the rules into operation. As with any procedural reform, their application is being monitored for any necessary adjustments. To complement the new probate and administration of estates rules, The court fees associated therewith were also revised and harmonized given the vast disparities across states, not to mention the very dated rates, some set as far back as the 1950s and wholly discordant with the services rendered. Simultaneously with the implementation of the probate rules, the court, after a consultative process, also implemented a harmonized suite of court filing fees. This was again necessary as the court fees across the OECS states saw many disparities and variations for invoking the same court process pursuant to the same rules of procedure governing those court processes. It was recognized that this disjointed approach does not serve the court as well as it should, as the court seeks to move to the next stage of reforming its processes through digitization and the use of ICT. Furthermore, there is still the perception held by many, by some, I should say, that courts simply drain the court's coffers of revenue. This is an ill-perceived view, but understandable when one considers the requirements for filing fees to be paid by postage stamps. These revenues are not attributed to the operations of the courts, but rather the operations of post offices. That said, it must always be recognized that the court is not intended to be a revenue center. Its mandate is completely different. Courts exist for the administration and delivery of justice to all, the state and subjects of the state alike. It was time that this court, like many other courts around the world, and in keeping with the independent exercise of its jurisdiction and powers, be allowed to manage in the same way that it prescribes rules of procedure, to prescribe by rules of court as envisaged under the Supreme Court order, the rates applicable to its procedures. This approach lends expression to the principle of the separation of powers on which all our democracies are based, and grounded as they are in respect for and adherence for the rule of law. By way of example, just as the judiciary cannot tell the legislative branch of government whether it should pass a law decriminalizing marijuana, or the executive branch whether to build a large or a small airport, so too the operation and management of the court's processes and the methodology it considers best suited for its operations as solely the purview of the judiciary. It is appreciated that the three branches of government must coexist and must interface, but each must do so exercising at all times due respect and deference to the boundaries of the other. One branch must not seek to exert influence over the other, lest the independent function of each be compromised and the principle of the separation of powers rendered worthless. The revised fees have been implemented in all but 2 states. This harmonized fee structure, which is to provide for filing fees to be paid by modern payment methods such as debit cards, credit cards, escrow account debits, and the like, helpfully places the court in the best possible position to realize one of the court's key objectives, that of bringing the court into the 21st century by the utilization of e-filing and enhanced electronic case management allowing for speedy classification and case scheduling so as to bring to the court systems an unheralded level of efficiency as well as transparency. The harmonized fee structure has provided the court, a regional court with a single jurisdiction running through the 9 member states and territories, the proper platform from which to launch the court's e-litigation portal. It is to this subject which I now turn. A few years ago, the court started on a search for electronic platforms to replace the GEMS software, which was an off-the-shelf, non-web-based software, which had clearly outgrown much of its usefulness over time, with little hope of providing needed upgrades to enable operations in a digitized and an electronically connected modern world. The court, like any other organization, had to decide whether to get on board or risk being left behind. We were in search of a solution that could be uniquely tailored to the needs of the Eastern Caribbean Supreme Court, as well as the magistracy, with a range of user-friendly features which would revolutionize the ease of doing court business right across the court's 9 member states and territories jurisdiction as a singular, cohesive, and integrated platform, operational and accessible from wherever practitioners may be. No doubt, the concept of the ease of doing business has a familiar ring. The economic outlook of countries is now routinely measured by the ease of doing business. It can be no surprise that the performance of the judiciary in its ability to timely decide disputes is a key factor determining where a country ranks on this internationally recognized business index. And so, with these considerations in mind, and being mindful of the objective we are seeking to achieve, we searched for a tested partner who could deliver a robust software platform, complete with technical support when needed. And so after conducting that review and observing the platform at work in Singapore, we were fully satisfied that the company, Crimson Logic, with their proven track record in many other parts of the world, including Singapore, in building e-litigation platforms for use in several common law-based judiciaries, had the quality product which is best suited for this court's operations. For over a year, the court has been collaborating with that company in designing and customizing the Eastern Caribbean Supreme Court's e-litigation portal. This involved fieldwork, examinations of our current operations, and discussions with stakeholders, both internal and external, so as to fine-tune the electronic mapping of the court's management processes in accordance with the court's instructions. Much work has been undertaken by the IT department of the court and other court personnel. I am happy to announce that we are now ready to launch the system, beginning with the state of St. Lucia and the court's headquarters, to be followed in short order by the territories of the Virgin Islands and Anguilla. The rollout will continue from state to state until all member states and territories are linked. I am excited about this development. It is my hope that all court users and staff will also be excited about this development. Following a tagline competition among court staff across our 9 member states and territories, I am pleased to announce that the tagline for the e-litigation portal is this: the ECSC e-litigation portal, serving you on time and online. The winning entry was submitted by Mr. Mervyn Toussaint of the Grenada High Court Office. We congratulate Mr. Toussaint for coming up with what I consider to be a most fitting tagline, given that the implementation of the e-litigation portal will bring about tremendous time and cost savings for current users and legal practitioners in a convenient and accessible manner. It will no longer be necessary to spend valuable time traveling to the court office to file a claim or a document in a case, or to seek to beat the court office's closing time, as was referenced as recent as last week. With the ECSC litigation portal, you will now be able to file anytime from any place. There will no longer be the need to physically attend the court office to conduct a search, and worse yet, spend valuable time awaiting the physical pulling of a file from some distant vault, cabinet, or other location, or lose patience over a misplaced and sometimes completely missing file. There are also the benefits to be derived from no longer having to prepare numerous paper bundles, which are both time-consuming and costly, and then having to truck them off to the court office for another waiting period of manual stamping of each copy. It eliminates the need for all the large storage spaces required within the court offices for proper safekeeping and the issues associated with quick retrieval. I have not seen a court office in recent times which does not suffer from inadequate space, while the mountains of paper continue to grow up around court staff, who are given the tasks of trying to do their best to keep track of documents in a physically challenging and oftentimes chaotic environment. With the e-litigation portal, trial bundles and appeal bundles can be created and uploaded online with a click. This should be music to some legal practitioners' ears, who have sometimes found it difficult to prepare, collate, and index the numbers of required trial and appeal bundles. The appellate court, which is itinerant, knows all too well the costs, time lost, and the stress involved in traveling back and forth across the sub-region with boxes and boxes of material at tremendous cost to the court, unfaithful Liat. It is a faithful airline, and we enjoy, thankfully, a very good relationship. We also have, as well, the on-land transportation and the additional manpower and resources at each point for moving all this weighty material, sometimes more than 3 times over. And our Court of Appeal, we have experienced, oftentimes in some states, some stressful times in relation to the movement of all of those boxes of material. And so the cost savings and efficiency to be gained from such a system are tremendous and, in my view, obvious. I see this step as the dawn of a new day in our continuous stride to improve access to justice and delivery of justice. I was privileged to hear a couple months ago the Minister of Jamaica, the Minister of Justice in Jamaica, speak of the new face of justice being implemented there by use of similar measures as I am addressing here. As I listened, I felt excited and happy for Jamaica. But I am even more excited for us in the OECS. As with the devising of rules of procedure for the operation and management of the court's processes, so too, the choice of the methodology or platform to utilize, whether by way of paper, be it white, pink, or blue, or by way of digitization, are all operational matters falling solely within the purview of the judiciary and no other branch of government, entity, or person. Of this much, I am certain. Nonetheless, it has been quite a journey over the past year, with some distractions seeking to creep in along the way in getting to this stage. The court, however, has remained focused and committed to its mission, to doing all within its power to provide better and greater access to justice and delivery of justice by using all avenues available to it for so doing. In addition to these initiatives, I also make mention of the court's ongoing efforts under the court's Courtroom Technology Enhancement Project. Under this project, the court has, step by step, been engaged in the procurement and installation of IT equipment to assist in transforming the courtrooms across the member states and territories to become more efficient by operating as a seamless communication center. The goal of this project as a first step is to equip at least one courtroom across each of the member states and territories with modern video and audio capability, as well as the digitization of court proceedings by using audio transcripts and ultimately transcripts in real time. It is our goal that in time, all courtrooms will be fully equipped. What are the benefits of these? Again, real savings in time, money, and improved efficiency. If a litigant or a witness can access the court without the need for travel by land, air, or by sea, but instead can fully participate in a proceeding by a video or audio link, then that results in tremendous cost savings to the litigant, including the state, in relation to airfares, land transportation, not to mention hotel accommodation and other attendant expenses. Of utmost importance is the enhanced security and safety, which this brings to critical witnesses, particularly in criminal trials. We are all too familiar with the fate that has befallen many such witnesses. It also enhances efficiency in the disposal rates of matters, which might otherwise have to be adjourned because of the inability of a witness or litigant to travel. In short, enhanced access to justice. I pause here to say this because I think I need to give this example. What improved audio and video technology does. This was amply demonstrated last week on the 11th of September when the Court of Appeal sat during its recess to hear an urgent appeal involving the grant of an injunction halting the construction of an international airport on the island of Barbuda. The panel of the court was constituted with 2 justices of appeal located in St. Lucia, 1 justice of appeal located in the Virgin Islands, with lawyers for one party located in Antigua, and lawyers for another party located in the United Kingdom. All this was facilitated by the use of video link, aided by high-speed internet. The hearing was seamless. All parties could see and hear each other. Notably, the judges were also able to confer amongst themselves in real time, as if they were in one physical space. A decision by the court was rendered on the same day. This is the standard we are trying to achieve for normal operations. This is achievable if there is the will on the part of the executive branch of governments to adequately resource the court. This brings me to the frustrations currently experienced by litigants and practitioners, as well as judges, with the current incapacity of the court offices across many member states to produce transcripts of court proceedings. This deficiency cannot be overstated. Right here in the Federation of St. Kitts and Nevis, there is a list of pending appeals, the bulk from the High Court, which are not progressing for the lack of transcripts. But the Federation is not alone. In some other states, St. Vincent and the Grenadines, Dominica, Grenada, the story is much the same, and in some cases worse. Transcripts of court proceedings are vital to the appellate process in the bulk of cases. This current incapacity has been rendered so by the failure of many governments to provide the courts with the needed personnel and equipment for the production of transcripts. Pleas have been made by me directly to governments. I have had discussions with government officials on these shortcomings, particularly in those states where the resultant delays in the ability of litigants to prosecute their appeals have become especially troubling. These failures are threatening and in some cases have resulted in a denial of access to justice. The ability to use transcripts or the production of real-time transcripts by the installation and use of modern equipment for this purpose provides a solution to this vexing and troubling problem. To my mind, the lasting benefits of all these measures are self-evident. They are all aimed at achieving one objective: proper access to justice and delivery of justice. If justice is not properly accessible at the bottom levels of the justice system, then there can be no accessibility at any level of the justice system. Access to justice is not calibrated to flow from the top down, but from the bottom up. I take this opportunity to again urge the governments of the member states and territories to support the court in these initiatives in order to improve for its people their ability to access justice and to ensure a better quality of the delivery of justice. I come to court facilities. The lack of proper court facilities is as old as the court itself. Over the years, I and Chief Justices before me have repeatedly spoken of and pleaded for the urgent need for governments to give some priority to and provide adequate court facilities. 51 years on, since the establishment of this court, little, if anything, has been done. Courtrooms are still housed in ill-suited buildings, which have posed attendant security and health risks to court users and occupiers. Whilst courtroom closures are understandable following the passage of hurricanes and the like, it is unacceptable that court users and occupiers have been consistently placed in harm's way in respect of their health and security. This year, we have experienced the closure of the criminal court facilities in St. Lucia for security reasons, and the closure of all courthouses in Grenada for health reasons. These failures pose a real threat to access to justice and the delivery of justice. I have urged the heads of those member states affected by the hurricanes to include the Halls of Justice project in their reconstruction programs. I take this opportunity to again urge all heads of government in member states to prioritize the construction of halls of justice and make them a reality. You, the people of this region, must be interested and must voice that interest in having these matters addressed. The courts are there to serve you, and you must become engaged in the changes you wish to see. The budgetary allocation for the operations of the court in any of the member states and territories is less than 3% of the annual budget of any of the states in any year. Yet, the financial position of the court, year after year, remains of grave concern. I am unable to stay silent about it. This court does not have the benefit of a trust fund arrangement, which at least serves as a buffer between the judiciary and the executive, which holds the power of the purse. This court must seek approval each year for its operational budget. Even so, the court is constantly faced with the failure of some states, and I say some states, not all, to honor their financial obligations. Arrears continue to mount in respect of monies due to the court. Currently, the aggregate of arrears in contributions due to the court stands at just over $22 million. These shortcomings pose real risks to the administration of justice as they affect the court's ability to plan and implement programs or to employ resources vital for bringing about reforms or to keep the court functioning as it should. These failures undermine access to justice and the delivery of justice. The current financial arrangement and the lack of insulation feeds the perception held by many that he who pays the piper calls the tune. Or put another way, that there is a real risk of the exertion of influence over the judiciary. It does nothing to dispel this perception or lend true meaning and purpose to the principle of the separation of powers and to protect against what can be an irresistible temptation. It is time that proper financial arrangements are put in place for the full and effective operations of this court, or foundational and constitutional courts. I therefore call upon all heads of government to address the situation and remove once and for all these perceived notions held by many across our region. This morning, the Reverend spoke about the fears that we have. Let us remove those fears once and for all and banish them. these fears are not dispelled by lip service, but by taking the appropriate action. It would do much to improve the confidence of the public in the justice system across the length and breadth of our region. That said, I think it is important to share with you some information in respect of the day-to-day operations of the court. Notwithstanding the chaos wrought by the killer storms and the persistent financial constraints experienced, the court has maintained a busy schedule. In 2017, 450 appeals were filed at the Court of Appeal. The Court of Appeal heard a staggering, I want you to listen to this number well, a staggering 1,302 matters consisting of full court hearings, chamber hearings, video and teleconferences, status hearings. In the same year, the Court of Appeal delivered 881 decisions, 67 of which were written judgments and 814 oral decisions. Place this in the context of the number of days in a calendar year. Don't leave out the court recesses each day. That's 365. That equates to an average daily hearing rate of about 4 matters and an average daily delivery rate of more than 2. This is with a complement of 6 judges, including myself, at the appellate level. I ask that you point me to any other court in this region or anywhere else for that matter, which carries this workload. At the level of the High Court, 7,197 cases were filed across all the member states and territories in 2017. In the same year, 4,851 cases were disposed. The overall clearance rate of cases for the year was 67.40%. That marked a decline from 2016, which was 83.65%. No doubt this decline was in part due to the impact of the hurricanes on the affected member states and territories. But for a more detailed and clearer picture of the trends in cases heard and disposed by this court, when I say this court, I mean across our OECS states, I urge you to read the court's annual report. It is available online at the court's website. You will find it interesting, the sheer volume of the work this court must handle across its member states and territories every year. You may ask, how is this achievable, given the constraints that I have highlighted? The answer lies right before you. The committed men and women of the judiciary who work tirelessly and with integrity to deliver justice to the people of our region. So we strive for resiliency. Let me be clear. I am not suggesting that there are not shortcomings or that there are not instances where criticism is justified. As Father Cassius reminded us this morning, no system of justice is perfect. We continue to strive for the ideal. However, the empirical data, which can be searched and examined by anyone interested, demonstrates that the court is in fact a success. Unfortunately, it is easier to criticize the few shortfalls and paint everyone with the same broad brush than it is to address the underlying causes and to provide solutions. I am always heartened when our court is complemented by persons from outside of our region. And when I say our region, outside of the OECS or farther afield within our region, and they complement us on the work and the performance of this court and how much they look to our court and the cases published on our website for guidance. If our website goes down for a day, calls or email queries flow in from regions as far away as India. This is testament to the global reach of our court in today's world. On that note, it is important for me to recognize the tremendous efforts of the persons who have ensured that this court has truly served the people of our states for the last 51 years, and their commitment to soldier on into the future. Firstly, the judicial officers of this court, including our magistrates, who work tirelessly every day, often under less than optimal conditions and with inadequate resources, but who continue to ensure the delivery of decisions that are fair and just. Secondly, and behind the scenes, the support staff of the court, working at various levels at the court's headquarters, as well as constituent court offices in each of the member states and territories. These are some of the most dedicated individuals you could meet, and who often go unnoticed for their unwavering dedication to the court and indeed their countries. The judiciary, whilst always striving to maintain its independence, invariably works together with other branches of government. The heads of government of the 9 member states and territories, we hope, will commit to providing an environment and adequate space for the court to undertake its work independently and impartially without fear or favor. To this end, we acknowledge the work of the various ministries of legal affairs and ministries of justice for the important role they play in providing the support to ensure the running of our court offices and the provision of spaces that are made to function as courtrooms and other facilities. We also salute the hard-working men and women who serve on the various police forces and correctional facilities across our member states and territories. These men and women work under extremely trying circumstances to keep you, the people of the Eastern Caribbean, safe and secure as best they can. We also thank the Attorneys General, Directors of Public Prosecutions, prosecutors, Crown Counsel, and members of the bar across the OECS for the hard work they do and the role they play in maintaining and promoting the rule of law and the proper administration of justice in our region. To the citizens and residents of the OECS, we work hard every day to ensure you have a justice system you can depend on and feel proud of. We know you place your confidence in us each day to do what is fair and just and to maintain a justice system of the utmost integrity. We will continue to work diligently to ensure that your confidence in your court never wanes. For over 50 years, this court has been a model regional court. Our hope is that as we transition into a more modern court, we will be able to better serve you. No doubt, the court will continue to exist in an ever-changing environment. New ICT solutions will be developed. New case law will emerge. New rules and processes will be drafted to guide the judiciary. The court will have to ensure it continuously reviews and makes the necessary changes to remain an institution at the forefront of all the changes that the future holds, or at least seek to keep pace with it. We ask you, the people of the Eastern Caribbean, for your continued support as we continue our mission to serve you and to serve you better as we undertake the measures of which I have spoken to improve your access to justice and delivery of justice. I end with an excerpt from the prayer by Reverend Christian this morning. We ask God to sustain us in our duties, to grant us humility and sound judgment, to forgive our errors, and to inspire us in our service. I thank you.
Without further ado, turn it over to the Honorable Attorney General, Mr. Baba Aziz, who is going to start the addresses for the bar.
My ladies and my lord, I recognize the presence of His Excellency the Governor Augustus Jaspet. I also recognize the Honorable Premier and the Honorable Deputy Premier. I recognize the Deputy Governor. And from there, I'll recognize the protocol already established. It is my pleasure to speak at this new law year. As we gather here today to usher in the new law year, it is important that we reflect on the unprecedented challenges faced by our justice system during the last law year. As we are all aware, on September 6, 2017, just a couple of weeks from the opening of the 2017-2018 law year, Hurricane Irma, one of the most powerful hurricanes ever recorded, caused widespread destruction in the Virgin Islands, Antigua and Barbuda, Anguilla, and elsewhere. Then, approximately 2 weeks later, Hurricane Maria also caused widespread destruction in Dominica and in many of the same territories and states which were affected by Hurricane Irma. Both hurricanes left in their wake destruction on an unprecedented scale and disrupted the lives of everyone in the affected states and territories. In the Virgin Islands, and I'm sure as elsewhere, the operations of government and the legal justice system were also severely impacted. On 8 September 2017, while we were still coming to grips with the devastation around us and the near total breakdown of communication and utilities, certain criminals added to our misery by embarking upon open looting of businesses and shops which had suffered damages. My lord and my ladies, we have already prepared legislation enhancing punishments for those who loot and for those who take advantage of disaster that struck territories. In the coming months, it is my belief that this legislation would be introduced in the House of Assembly. The chambers had previously drafted legislation which was brought into force for a declaration of a period of public emergency in the territory, and it resulted in His Excellency the Governor acting in accordance with the advice of Cabinet, bringing that legislation into force on the 8th of September 2017. This legislation was followed by a series of regulations authorizing the imposition of a curfew, and ultimately a Curfew Act was passed. Furthermore, consequent upon the risk posed to the community by the escape of prisoners at Her Majesty's prison at Bassam Gulf as a result of the extensive damage to the prison, regulations were also drafted by the chambers with the assistance of Bermuda and enacted into law to facilitate the transfer of certain prisoners to St. Lucia. Milady, it is important at the opening of the law year as legal professionals to reflect on the ideals of our noble profession. Crucially, we should always adhere to the highest ethical standards, particularly given that a breach of ethics may, under the Legal Profession Act 2015 as amended, become the subject of disciplinary proceedings. May I announce, if it is not already known, that the 7-member disciplinary tribunal envisioned to be established to uphold the standards of professional conduct and of enforcing the code of ethics set out in Schedule 4 of the Act, pursuant to Section 27 of the Legal Profession Act, has now been fully constituted and is chaired by Ms. Sally Cox. Let us therefore redouble our commitment to voluntarily uphold and maintain the highest ethical standards required of us by the Act and of our noble profession. The attention of the general public is being drawn to Section 28 of the Act, which provides a simple gateway to litigating before the disciplinary tribunal issues of professional misconduct by persons aggrieved by such misconduct. The clients themselves, the Attorney General, and third parties, with leave of the tribunal, have standing to bring such matters. The inclusion of the Attorney General on this list is a codification of the common law aspect of the public interest function of the Attorney General espoused by Lord Denning in the Privy Council decision of Pierre Sarinjai versus Attorney General of the Gambia, which is to be found in 1961 UKPC 19. Miladies, I'm not unaware of the number of allegations of unethical behavior against some legal practitioners. Please permit me to refer to a few clauses of the Code of Ethics contained in our Legal Profession Act to make this point. Duty to the territory. A legal practitioner owes a duty to the Crown and the public to maintain the integrity of the legal profession, to uphold the Constitution and the laws of the territory, and not to aid, abet, counsel, or assist anyone to act in any way contrary thereto. I'll refer to 43. A legal practitioner shall not accept instructions to act in court proceedings in which, to his or her knowledge, the client has previously been represented by another legal practitioner, unless he or she first notifies the other legal practitioner of the change, but shall be deemed to have notified the other legal practitioner if he or she has made reasonable efforts to notify him or her. Finally, 44. A legal practitioner shall not accept instructions to act in proceedings other than court proceedings in which, to his or her knowledge, another legal practitioner has previously represented the client, unless he or she makes reasonable efforts to ascertain that the retainer of that legal practitioner has been terminated by the client, or that the client wishes both legal practitioners to represent him or her. My ladies, in the light of the above sections, read together with Section 58 of the Constitution and Section 3 of the Crown Proceedings Act, Cap 21, I would venture to suggest that it is misconduct for a private legal practitioner to initiate action demonstrably geared towards usurping constitutional, statutory, and constitutional functions of the Attorney General. Regrettably, I have had to defend the office in this regard. There is case law supporting the proposition that a breach of constitutional and statutory provisions is not excused by good intention on the part of those who breach these provisions. Miladies, I respectfully submit that in a democratic society such as ours, based on written constitution, complemented by unwritten principles of separation of powers and the rule of law, and supported by a robust system of judicial review, there is no need for the office of the Attorney General to defend the functions of that office from encroachment, especially with respect to powers specifically conferred on that office by the legislature in the public interest. In his famous dissent in Livesey versus Anderson, now hailed as one of the most important constitutional decisions in recent legal history, Lord Acton said, "In this country, amidst the clash of arms, the laws are not silent. They may change, but they speak the same language in war and in peace." He was alone. He was a lone voice, but he spoke up. I do so even if it means in this specific context, I'm disregarding the caution contained in the literal words of the first part of Amos chapter 5 verse 13, that therefore the prudent shall be silent. It is my hope that the case of Attorney General of Fiji versus Director of Public Prosecution 1982 UKPC 34, in which a constitutional question was litigated between two public officers with respect to the exercise of constitutional functions, would not be repeated here in the Virgin Islands between the Attorney General and other public officers. Even though it was a case between Attorney General of Fiji and Director of Public Prosecution, may I state that this is in no reference to my learned friend on my left. I respectfully do not think that in a territory such as ours, based on a written constitution, coupled with unwritten principle of constitution, namely the principle of separation of powers, the rule of law should be undermined in any way. The Attorney General's chambers would continue to perform its constitutional mandate as principal legal advisor to the government, and in doing so would always be guided by the rule that governmental actions ought always to be underpinned by the rule of law. It has now become a cornerstone of the address of the Attorney General on the opening of the new law year to report on the efforts of the chambers toward the implementation of government's legislative agenda. In this regard, we continue to work with other departments, including the Financial Services Commission and other partners, to strengthen the financial services sector of the territory, particularly in strengthening the regulatory regime in order to keep pace with the standards which continue to be set by various international institutions. Of particular note is the passage of the Beneficial Ownership Secure Search System 2017 to assist with the timely retrieval and sharing of beneficial information with law enforcement agencies around the world in aid of the investigation and prosecution of various forms of illicit activity. My ladies and my lord, notwithstanding the passage of the above enactment, the enactment by the United Kingdom Parliament of the Sanctions and Anti-Money Laundering Act 2018, which seeks to compel us to have a publicly accessible register of beneficial ownership of companies, has stirred controversy in the United Kingdom, in the Virgin Islands, and in most overseas territories of the United Kingdom, especially so when the Crown dependencies have been left out. I note that Section 51 of that legislation is still not yet in force. It is hoped that in the coming months we may be able to have a resolution to this matter. In closing, I wish to welcome all those who were called to the bar during the last law year. While I welcome the new members, I take this opportunity to remember all those we have lost over the course of the past law year. As I welcome the new members of the bar, I wish to also encourage the senior members to continue to do their part in the nurturing and development of the new members. We all recognize that the opening of each new law term is particularly instructive, as it provides an opportunity for us to rededicate ourselves to the ideals of our noble profession, including the dispensation and pursuit of justice in all arenas, be it commercial, civil, criminal, or administrative, and for us to refocus on the primacy and importance of the rule of law. Finally, I wish to thank the staff of the Attorney General Chambers for their support and the role they have played over the past particularly challenging year. Thank you.
Thank you very much, Mr. Odini, for that opening. We'll continue with the addresses for the inner bar.
It is my pleasure to be here today on this occasion to mark the opening of the new law year, and indeed to be addressing this court. First of all, let me say that I don't think I've had the pleasure of doing it before, welcome Justice Smith to the jurisdiction, and I trust that your stay with us would be one that you would enjoy in terms of the challenges of the law, and that you will get the kind of support that the court deserves. as you sojourn through your stay with us here in the British Virgin Islands, of which you have a more than a passing familiarity. I also would like to take the opportunity to welcome back Justice Adderley, who hails from the Bahamas. I went to a law school with an Adderley. Maybe there's some relations, I'm not quite sure. But do welcome back to you, Justice Adderley, and of course, Justice Ellis, our presiding judge this morning. We welcome you again, and we thank you for sticking with us, notwithstanding the ravages of 2017. I'm not going to refer to the protocol, I must say, because I have more than, I'm not one who likes to rattle off the protocol, and I don't like to say the protocol already established either, so I take it that it is already established and I move right through. In the interest of time. As we gather today to commemorate the new law year, following a format that has now become a tradition in the BVI and in other jurisdictions served by the Eastern Caribbean Supreme Court, and of course tradition has its place and importance, we do so mindful of where we are now as a territory ravished by a great flood and two very destructive hurricanes of historic proportions. In doing so, it is important to look back over the last 12 years, ever mindful of the life-threatening experience we all went through together, and to the progress we have made collectively as a people and country during that period. These memories will forever be with us, forged from a common or shared experience, in some respects a shared tragedy of monumental proportions. Our recovery and progress has been slow. It has been most challenging and taxing. It has been a great physical and psychological burden. It has taken its toll on our lives and on those around us. It has given rise to debts, to frustrations, to delays, to new and huge challenges. We have a long way to go in our recovery and restoration, not to mention our future development. We are still grappling with the steps so necessary, nigh so essential, to the commencement of the recovery in earnest, to put us on a clear path to progress and ultimately prosperity. The frustrations are many and varied. At times it seems like we are not doing much, and the signs of it are all around us. It is therefore most fitting that today we gather as a court under the theme, Challenges, Opportunities, and Resilience, the Eastern Caribbean Supreme Court paving the way to a modern and efficient judiciary for the Eastern Caribbean. Despite the profound and widespread effects of the 2017 hurricanes on this territory, it has brought out the good and bad in us, from the rampant looting to the many acts of kindness and caring, from the cavalier and lawless behavior we all experience, especially from the looters and I dare say from the users of the roads, to people coming together for a common purpose to help those in need. This experience has in some respects brought us closer together as a people and as the inhabitants of these beautiful islands. This has been so irrespective of race, color of skin, nationality, or ethnicity. It has, in my view, illustrated in practical terms the true meaning of the Protection from Discrimination Clause in our Constitution. Most importantly, the shared experiences of 2017 has underscored and given renewed life and meaning to aspects of the preamble to the Constitution. A belief in God, the dignity of the human person, respect for the rule of law, a free and independent spirit, the development of our people based upon qualities of honesty, integrity, mutual respect, and self-reliance. Yes, these shared experiences, as bad as they were for all of us, for no one was spared, have been demonstrable of our continued bond and kinship with these islands. In short, it has demonstrated our resilience as a people and also the commitment of many others to these islands and to assisting not just with the recovery and restoration, but with our continued development. These private individuals did not walk away and leave us in the destruction and despair. They stood with us. They used their resources to assist us. They came, and we owe them a debt of gratitude and thanks. And while we all enjoy the fundamental rights and freedoms enshrined in the Constitution, including freedom of speech, we must be ever mindful of what we say and how we treat others among us, people who have made these islands their home and have, like us, a personal stake in its future and continued prosperity. Some of these individuals are now financing the rebuilding of aspects of our infrastructure, such as our public primary schools. Too often, our system of justice and of law and order is not accorded the priority they deserve. The aftermath of the 2017 hurricanes have brought into stark focus the importance of the preservation of security and law and order to the economic well-being and prosperity of the BVI and to the quality of life we all have come to enjoy. For far too long, we have neglected providing proper court facilities for the magistrate to the High Court. We have underfunded our police and law enforcement agencies and border protection agencies. When we speak of resilience and building back stronger and better, we ought to have in mind building and developing a proper infrastructure for our courts and police. This is critical to our orderly development as it is to the maintenance and preservation of life and law and order in our society. Accordingly, my request today is that our country finally ensures that the design and building of the long awaited Hall of Justice to properly house our courts and registries, a project that has been around for decades, is prioritized, funded, and commenced in earnest. I trust and I believe that an assurance has been given that funding for this project is in the Recovery and Development Plan, now finally laid on the table before the House of Assembly. Likewise, we must treat our police force better than we have in the past. We must provide them with the buildings and facilities necessary for them to do their difficult job and to do it to the standard necessary to effectively fight crime in the BVI and to bring offenders to justice. There are many other steps that must be taken to provide for a modern and efficient judiciary. These must be brought to the fore and kept on the front burner, so to speak, as we move forward in our recovery phase. May it please your lordships.
My ladies, my lord, may it please you. I am grateful, as we all indeed must be, to be able to be here this morning, or it's virtually noon, I keep looking at that clock, to be here this morning. I'm personally grateful to have the opportunity to address the court on this, the occasion of the opening of the law year 2018-2019. And may I pause to welcome you back, Madam Justice Smith, this time as a judge of the High Court, to our jurisdiction. And Justice Adderley, I do not think that I have ever had the opportunity in a formal court setting to welcome you, and I do so very warmly. And of course, our dear old Madam Justice, not old, our dear Madam Justice Ellis is always with us. My ladies, my lord, by act of God, none of us could be in this place at this time last year.
and we remember. And we remember many things. And in particular, we remember the many who have departed this life. And I wish to mention in particular Charmaine Roseanne Bunbury, the Honorable Magistrate Charmaine Roseanne Bunbury, who sadly departed this life on Old Year's Day last year, the 31st of December, 2017. Charmaine was not accorded the privilege, which in my experience of close to 40 years at this bar, has been accorded to every lawyer who dies. That privilege being a special sitting of the court in memory of the departed lawyer. And I sincerely believe that it would be deeply remiss of me if I did not this morning, today, mention and place on record our tribute and our thanks to the late Charmaine Roseanne Bunbury. She was a member of the legal profession. She was a member of the judiciary, and she served well. At 4 o'clock this morning, I got on my phone the list for the Court of Appeal for its sitting on the 31st of October to the 2nd of November. Her name is on that list. And I believe very firmly that in the fullness of time, Charmaine's true worth and her true sacrifices and her contribution to this country and to justice and to the development of justice will be appreciated. History will absolve her, and her contributions and her sacrifices should not go unnoticed and unrecorded. And I place on record in this court today our tribute and our thanks. And I remember her family. One of her relatives may be here when there's a grieving widower and 3 small boys. It was in February last year, my ladies, my lord, that we met here in this very room in a special sitting to mark the 50th anniversary of the establishment of the Eastern Caribbean Supreme Court. It was a significant milestone in the life of the court and in the lives of the people of the Virgin Islands. It was an event, I believe, that was truly an anniversary worthy of celebration. I did not say it then, but I say it now, that for close to 40 of the 50 years of the existence of this court, I have been called to its bar and privileged to stand in this place. As I stand here today, my thoughts are, as I stand here today, convened as we are under the theme, Challenges, Opportunities, and Resilience, the Eastern Caribbean Supreme Court, paving the way to a modern and efficient judiciary for the Eastern Caribbean, my thoughts are the following. Perhaps at this time, it is time for us to be less laudatory and more focused on and objective and candid in our assessment of where the institution of the judiciary is and where it should be. Yes, there is certainly much to continue to celebrate and much to be proud of, and I pay tribute as tribute is due. But I say, my ladies and my lord, as the rule of law is increasingly threatened, as governance and institutions are being weakened, as there is a seemingly continuing blurring of the separation of powers and a commingling of the 3 branches of government, the judiciary has to be and must remain robust. It must jealously guard its independence, and be the bastion of the preservation of the rule of law, and ensure that our democracy remains alive and vibrant. So one asks, are we best served by an increasing pattern of acting and ad hoc appointments to the bench? Are we building capacity and building the institution of the judiciary? Is the process for the appointment to the bench sufficiently open, transparent, and participatory? Is our jurisprudence being developed? What are the costs? What are the costs, financial and otherwise, to the system and to the good taxpayers? Is the court being made more subject to interference from the political directorate and special interests by this pattern? Are we best served by an itinerant court of appeal? And I listened to, and with great feeling, for our learned Honorable Chief Justice Dame Janice Pereira. What of the physical toll on the judges, their private lives, their families, their safety, and their security? Are litigants best served in this day and age by an itinerant court of appeal? How do the factors cited impact the independence of the judiciary? What are the overall costs, I ask again, financial and otherwise? Should judges engage actively with the media? Should judges participate in town hall meetings? I've been engaged in the last few days in a healthy debate with some of my senior colleagues in the region on that very issue because it is emerging. These, I submit, are among the factors which must be addressed as we seek to pave the way to that important necessity for democracy, a modern and efficient judiciary. And there is more, much more than that. The administrative support for the judiciary needs to be enhanced. And again, our learned Chief Justice spoke passionately to that. And I speak of the registry of our Supreme Court. The registry is, as it were, the engine room of the courts and the important cog in the functioning of the judges and the delivery of justice to every man and woman, of course. I recognize and wish to thank publicly our registrar, Madam Registrar, and the team that she leads. They work day in and day out in strained circumstances and in less than ideal physical conditions, conditions that are less than befitting. And I speak of pre-Irma and Maria, and what can I say about post? But as we look at making our judiciary more modern and more effective, as our theme says, an objective look has to be taken at our registries, and our registry here in the Virgin Islands in particular, I speak of. Greater financial and human resources must be provided to our registry, and modern and efficient technological systems, ICT, and all related facilities ought to be provided. The judiciary indeed cannot function properly without the support of the legal profession. A users committee, as well as a strong bench bar committee, is critical to the full functioning of the judiciary. I have heard anecdotally that a bench bar committee is being revived. I have not myself been directly approached about or involved in it, but it is an initiative which I support and which I wish well. And I would make the point, and I make this very strongly, that the bench bar committee should be broad-based, it should be inclusive, and it should be truly representative of the legal profession in the jurisdiction. And while we're at that, I feel that I should say something I feel very passionately about, which is that it is time now, time since 2009, when it was first established, that a critical look is taken at our commercial court, its efficiency, its efficacy, and how it functions and how we can improve it. It is an extremely important part of our life and of our economy and of justice in our jurisdiction. The legal profession, as I said, has to continue to be very supportive of the bench. The Virgin Islands General Legal Council, which I have the honor and the privilege to chair, was established by the Legal Profession Act of 2015. The members of that council know that I am concerned that the two amendments which were made to the Principal Act in a very substantial way impacted the efficacy and the ability of the Virgin Islands General Legal Counsel to perform. One effect of the amendments is that the regulation of the profession, which should really vest in the profession itself, is in fact by virtue of especially the Second Amendment in January 2016, placed in the executive of the government, that's the cabinet, and not in the legal profession. That fact, in my considered view, has serious implications for the rule of law, and sometimes we do not see these things today. But it has serious implications for the rule of law, and it ought to be changed. And it can only be changed by legislation. And there is the added fact that the council has never been financed. The council has never been given any budget. The council has never been given any staff, any human resource capacity, other than our dear, I don't want to say old again because that gets me into trouble, but our dear registrar and the already overworked and overburdened team in the registry. But those realities notwithstanding, my ladies and my lord, the General Legal Counsel is trying. And I'm pleased to announce that in the course of this law term, in fact, on the 2nd of November this year, the Virgin Islands General Legal Counsel, in partnership with the BVI Bar Association, the American College of Trial Lawyers, and others, will be hosting a one-day program on effective advocacy at the BVI Arbitration Center. My lords, my ladies, my lord, I know that you will, with your good selves, grace that program with your presence, and we have our distinguished Chief Justice who will also be participating, and Sir Dennis Byron, the recently retired President of the Caribbean Court of Justice and the former Chief Justice of this very court, will also be part of that program. And may I just pause to invite all lawyers, all members of the profession here and not here, to attend that workshop, that event, and to participate fully in it. We believe that it's a very important initiative to assist the development of our jurisdiction. The Virgin Islands General Legal Counsel is also working on an anti-money laundering code of practice for the legal profession. We believe that this is important for us as a profession, and we believe that it is a very important addition to all the frameworks, all the regulatory components in our jurisdiction, and to which we know our government is unreservedly committed. My ladies and my lord, at the special sitting of the court on the 50th, in February last year, I spoke of the abysmal physical conditions in our magistrates' courts. I said at the time that I do not regularly practice in the magistrates' court, but I had had occasion to be there, and little did I know that a few months later, the facilities would be completely destroyed. And while one fully understands the reality which we found, and one appreciates and understands the economic and financial reasons behind the very quick and very ready establishment or re-establishment of the commercial court, many persons in our community, and I include myself in that, are concerned that it took such a very long time for the civil courts and the criminal courts, for the High Court in its civil and criminal jurisdiction, as well as for the magistrates' court to begin to function. My ladies, my lord, I was alarmed to read in either the Beacon or the Island Sun over the last weekend an announcement asking for persons who had matters pending before the magistrates' court on the 6th of September to contact the court. That is not good enough. I say with the greatest respect and with the most profound understanding of all of the constraints. I was in every line after Irma, the gas line, the food line, all the lines, so I understand. But we have to do better, and we ought to put in place, as we look to building a more resilient judiciary, as we look to the path for efficiency, efficiency and modernization of our judiciary, we have to have in place arrangements that can avoid such a reality in the future. The Magistrates' Court, as we all know, is for most citizens the face of justice. It is the first contact, sometimes the only contact, that a person has with the judicial system. Sometimes it's a routine traffic charge, a domestic matter, a domestic dispute, a serious criminal charge, murder, rape, or whatever, a civil claim of up to $10,000, a landlord and tenant dispute, and there are many of those these days post the hurricanes. There is, in my view, and I say this clearly, my ladies and my lord, an important obligation to give more dedicated focus to and attention to the institution of the magistracy. It should be provided with greater resources, and that discussion, which has gone on for, I believe, at least 20 years, about integrating the magistracy into the higher judiciary should cease to be a discussion and should become a reality. Delay in the court system remains a vexing issue and one which has to be addressed drastically. There's a citizen who files an application in a civil matter in December, supported by a very detailed certificate of urgency, gets a first hearing in March, gets a substantive hearing in June, and cannot get the signed order until August. Does that citizen get justice? Does that citizen get justice? I know that there are challenges, and I do not speak pretending that they're not there. But one of the things I would like to suggest is that, and to urge, is that we all make greater use of the alternate dispute resolution processes. Madam Justice Ellis, I know you have put a great deal into trying to activate and use the mediation processes which are available to us. And I would like today from this place to urge greater use of the alternative dispute resolution processes, in particular mediation, and of course there's arbitration. Our government has made what I personally believe is a great and good investment in an arbitration center. It's well equipped, it's world class, and I do think that we ought to use it and to make better and more consistent use of it. So I close by saying that our collective efforts are needed to improve and enhance social justice, its delivery of justice, and a modern and efficient judiciary. I pledge my own personal support, that of my law partner, Astra Penn, to this end. And I urge all of the members of our profession to do no less. My ladies, my lord, my sincere wishes for a very successful and productive law year. I'm obliged.
Thank you very much for that, Mrs. Dancia Pensala, Queen's Counsel. Valuable contribution as always. I'll hear now from the Director of Public Prosecutions, Ms. Kim Hollis, Queen's Counsel.
May it please you, my ladies, my lord, your excellency, Mr. Augustus Jaspert, Governor of the British Virgin Islands, the Honourable Premier, permit me to adopt the protocol already established by those who came before me. As a result of the events of last September, this is only my second address to this Honourable Court on this annually unique occasion, namely the opening of the legal year. This year, it holds particular poignancy for myself and my department, as it marks the restoration of our criminal justice system as it returns fully to serve the Virgin Islands. And I want to commence by paying tribute to all of those employed in the Office of the Director of Public Prosecutions, prosecutors and administrative staff alike, for all their hard work in keeping the wheels of the criminal legal system in motion during the past difficult year, and the challenges we have had to face in bringing to justice those who would threaten our safety and security by by the commission of serious criminal offences, attempting to take advantage of the effects of the devastation of 2017. My officer's contribution in each and every case that has come before the criminal courts cannot and should not neither be underestimated or overlooked, as they have played their important role in the maintenance of law and order. Equally, we are all alive to the very future real demands on our office due to the backlog that exists as a result of the hurricanes. And although I know we will work tirelessly to assist the courts in each and every case, it should remember that our capacity within my small office is finite, although we are the crucial linchpin between the police arrests and the courts. Police and court capacity has been increased. However, the urgent corollary need for prosecutors within the courts should not be overlooked, as they are also an intrinsic spoke in the justice wheel. On the last occasion I addressed this court in this capacity, I indicated then, in the short time I'd been in office, that I had set up teams of specialist prosecutors within my office to develop expertise in specific fields in order to be involved in a case from the very beginning, namely arrest to conviction, thus ensuring both continuity and confidence as far as the public and community are concerned. This procedure has proved to be an efficient and successful tool in expediting the prosecution of serious crimes committed on the territory. The teams are now highly experienced within their specialist fields, and it is as a result of the involvement of the prosecutors advising the Commissioner of Police and his officers during investigation and charge that you have seen that successful and prompt arrests during 2018 in particular of those alleged to have committed the most serious offences, in particular the alleged murders on the island. Often, it is unknown, but often, over a weekend and long after hours, myself and my senior prosecutors are consulted by officers during an investigation and indeed ultimately advise on the evidence as to the relevant and appropriate charges to be brought in each and every case. This, in my view, is a welcome safeguard in ensuring justice to all concerned, in particular the victims of often dreadful crimes. It was as a result of my advice that all those charged with a crime should be brought to trial within a reasonable time, in accordance with their constitutional rights, that despite the challenges presented by the hurricanes, the Audio-Video Link Act was enacted to ensure the continuity of our criminal proceedings during the past difficult year. And it will have been noticed that the witness anonymity legislation that I spoke of 2 years ago was earmarked in the speech from the throne by His Excellency earlier this year, and is not only well on its way to becoming law, but indeed has already been highly instrumental in a number of cases when witnesses to serious alleged offences have come forward knowing that they may well be able to be offered anonymity as witnesses in future criminal proceedings. Thus, before being enacted, the proposed legislation has already proved to be a potentially crucial evidential weapon in our armoury. Additionally, in relation to gang-related crime on the territory, insofar as it relates to drugs and other serious crime, the Commissioner of Police and myself are collaborating to bring before the courts a specific police expert witness in relation to local gang evidence, which is in our experience often the motive behind serious offending. It is now settled law, endorsed by the Privy Council, that such evidence is highly relevant and can be taken into account by a jury during a criminal trial, and a local officer with specialist knowledge may provide, to use the words of Lord Hughes, an important strand in the rope of evidence that there had occurred a trigger event which would have created a grievance in the gang of which the defendant was a member, and is admissible as in itself it significantly advanced the Crown's case by demonstrating motive, helping a jury to resolve one or more issues in the case. Turning to other work within my office, equally in anticipation of the future mutual evaluation in 2020, we are all working hard in relation to economic crime and money laundering, and have had notable successes in the last year in relation to the seizure of large quantities of cash for the territory. Indeed, as may have been noted, as recently as August 2018, the 28th, the court ordered the forfeiture of $577,830 in cash, which was seized at the airport as the defendant attempted to leave the territory, as well as ordering him to pay a further $170,000 as a fine, making a grand total of just under $750,000. I have recently returned from a global symposium in the United Kingdom on economic crime, which was attended by over 2,000 delegates from 100 countries. It was notable that much time and debate was devoted to the recent obligations that have been imposed on the Caribbean islands in relation to the public register of beneficial ownership. The heartening central theme running through the words of many global speakers who were all essentially ad idem was that unreasonable requirements were being placed on the islands of the Caribbean by those far wealthier jurisdictions who themselves were the known and identified centres of money laundering, where the proceeds originated, and that the onus should not be on these small islands, but on those jurisdictions from where the investments emanate, and there must be a sense of proportionality as far as the Caribbean islands had acted at all time in good faith. It was agreed at the symposium that there is an over-regulation. Further, in assessing the compliance of the British Virgin Islands for mutual evaluation purposes, as well as being results driven here in the British Virgin Islands, crucially, results should, in my view, also take account of and be reflective of our fulfillment of our obligations and successful MLAT cooperation, and just how many successful prosecutions have resulted in other jurisdictions due to our prompt cooperation and supply of requested information. The Office of the Director of Public Prosecutions continues to expand our knowledge and expertise in these areas, and indeed I have recently advertised for specialist counsel to contribute to our fight against economic crime and assist in building a solid foundation within the office, enabling us to advise and prosecute when necessary. As I sit down, I reiterate the words of Lord Bingham as far as the Office of the Director of Public Prosecutions is concerned. Aspirations without action is sterile. It is deeds that matter. We are all enjoined to be doers of the word and not hearers only. It is on the rule of law that the quality of government depends. That has been the motto of my office during the last year in particular, and will be during the coming year, whatever the challenges. I'm obliged to have been given the privilege to address you all today, and as I stated on the last occasion, I regard it as a great honour to be your Director of Public Prosecutions, and I wish the court and all counsel a productive year. Thank you very much.
Thank you very much for that, Madam DPP. We now move on to the Utter Bar. We'll have the address by the President of the BVI Bar Association, Mrs. Aspinall.
May it please you, my lords, my ladies. I am quite saddened to say that I'm nowhere near as learned or as brave as the Queen's Counsel that have gone before me, and so I hope you will allow me to adopt the protocol that has been previously established. I think that the decision of the Chief Justice to adopt this year's theme and to use three words that I think us in the BVI are very familiar with at this point in time of challenges, opportunities, and resilience is quite timely, and I'm grateful for her speech. I know that for us, the challenges brought forth by Hurricanes Irma, the promise of Hurricane Jose and Hurricane Maria, presented us with a challenge of a lifetime, and one that we hope we will never see again. I myself remember the feeling of waking up on September 7th and being overwhelmed by the horrible images that faced me and having a sense of hopelessness at seeing the devastation that had been visited on these beautiful Virgin Islands. And I have to be honest and to say that I felt in the days after the event that the rule of law had been irreparably broken down and was at its lowest point in this jurisdiction. I personally witnessed shops being broken into. I personally witnessed the looters at work. I heard horrible stories of prisoners on the loose. I heard that all of the High Court judges of the territory had been evacuated, and I saw with my own eyes the physical devastation that had been brought to bear on the Magistrates' Court and the High Courts and all the physical vestiges of justice that we have grown accustomed to. Time and time again, when I met with the common man on the street, in the days, weeks, and sadly months following the events of Hurricanes Irma and Maria, I was told of the underlying sentiment among the BVI population that it seemed as though access to justice had, like so many roofs and windows in this territory, simply blown away, vanished poof, so that persons who wished to access justice were being told that for various reasons, their ability to do so was impeded. Having said that, I think we all watched and waited expectantly. And unfortunately, though it took a little bit longer than I think we all had hoped, we had to recognize that the roots of justice are deep and that they cannot be suppressed. And that in the same way that slowly the naked trees in these islands slowly started to grow green shoots yet again, we saw over time the establishment of alternative mechanisms so that access to justice was once again replaced. The magistrates are not here today, but I want to publicly acknowledge them and applaud them for all of their efforts immediately after the hurricanes and for the steps that they took in terms of seeking alternatives. And so they sat at the police station and did what they needed to do in order so that people would be able to have matters heard, and so that even some of the looters that were caught would be able to be brought to justice and that their matters could be adjudicated and that they would be brought before the courts. And the registry, of course, also played an active role in that it quickly tried to open its doors to facilitate the hearings that needed to be held, and also took other steps so that practitioners could be brought before the courts and could have their matters heard. Sadly, however, one of the things that became evident in the aftermath, and one of the challenges that we faced, was that the registry, we learned, is not independent in terms of its IT function. And so immediately after the hurricanes, while several persons in the commercial realm were speaking about the great resilience of the Financial Services Commission and the ability of that commission to incorporate a company the day after the hurricane. And while searches could be done in relation to companies incorporated in the jurisdiction, very sadly for practitioners who tried to carry out high court searches with respect to those same companies, they were unable to do so because the registry's IT system, we all became shocked to hear, was inextricably linked with that of the government. And so when the government's IT system failed, very sadly, the registry's IT system failed. And for several days, there was an inability for us to search the court's record under the previous system. So I would like to take this opportunity to ask the powers that be to look into finding a solution for that situation. I would ask that every step be taken to ensure that the courts, in the spirit of it being an independent system, should have its own IT platforms and should be able to have its own systems in place for the continued accessing of those systems. Now, I know that the Chief Justice spoke about the implementation of new technological advancements with respect to the court system. And I know I speak on behalf of all of the members of the bar when I say that we look forward with great enthusiasm to being given service from the courts that are on time and online in accordance with the system that is being adopted. We very much hope that efficiencies will be created as a result of the introduction of this technology. We very much hope that there will be a swift movement towards the adoption of all things technological, so that e-filing will continue to grow from strength to strength, and that we will see greater reliance on e-filings, on electronic payment mechanisms, and of electronic care management in relation to the courts. We recognize the importance of the registry. It is, as has been pointed out by Queen's Counsel Dancia Penn, the engine room of justice. And there have been some challenges there that have been felt deeply by the members of the Bar Association. And we trust that with these new technological advances and with the normalcy that is being returned to these islands, that some of those challenges will be addressed and that better days are very near in the future. We hope that with these technological advances, that we will recognize that whilst most laws are not extraterritorial in nature, that we will be forward-thinking so that even though physically we may not all be in the same place by virtue of online systems and the video conferencing that has been mentioned before, we will be able to recognize that justice should never be limited by physical presence or by borders. On that note, I want to reiterate that the courts in this jurisdiction have very often not been given the attention that they needed to be. But having said that, I am very heartened and very pleased, and I would like to extend the appreciation of the bar to the government in relation to the provision of the new prefab magistrates court that is now in place. We visited it and we're very grateful for the implementation of that, particularly since the magistrates court is so badly damaged. We are also very heartened by the fact that provision has been made, at least on paper, for halls of justice to be put in place. And like so many others, I hope that the money, which is also paper, will be provided so that the halls of justice will become a reality. So while we've spoken about the challenges, and my predecessors have weighed in heavily on that, I want to talk a little bit about, well, the opportunities that we see. And for our part, the members of the BVI Bar Association stand ready, willing, and able to embrace new technologies, new systems, new opportunities, and to work diligently with the judiciary and the magistracy. We have, in fact, been working behind the scenes, and I can tell Learned Queen's Counsel Dancia Penn that a bench and bar committee is not only just something that is being murmured in the back halls, but is actually on its way to being restored to this territory. And we actually have a meeting tomorrow to try to move this initiative forward. So the BVI Bar Association fully and completely backs that, and we are trying to make sure that by next year we will have systems in place to ensure the free discussion between members of the bar and members of the judiciary and members of the government with respect to the needs that are out there so that justice can in fact be served. Also from that perspective, the Bar Association is committed to continuing legal education. As has been mentioned, we are now under the auspices of the Legal Profession Act. But while the Act was passed some time ago, several of its provisions are not in force. And that has put us in a very precarious position. I'm very happy that the Attorney General has pointed out that one of the long-awaited provisions of the LPA is now again on paper in place, in that we now have the appointment of a disciplinary committee. I had heard that it had in fact been constituted, but I was waiting on the announcement, and I see that the AG was waiting on this auspicious occasion to let us all know about it. So we look forward to its functioning, and we look forward to its operation in the way that we all know that it needs to. In closing, I just want to acknowledge again the hard work that has been done by the registry, particularly in the face of the challenges that has occurred. And in particular, following on from the hurricanes, the swift movement that was taken in terms of the commercial court and its restoration in St. Lucia so that it could continue to operate. The members of the Bar Association are deeply grateful for all registry staff and their efforts, but in particular, the members have asked me to single out the hard work and dedication of Deputy Registrar Noni Georges and the judicial clerks of the commercial court, and of course the judges of the commercial court, who quickly relocated and through their efforts managed to facilitate the smooth operation of the commercial court in St. Lucia until it could safely be brought back home. I'd also like to thank the members of the magistracy, and I am very saddened that they are not here. But as the Chief Magistrate often says, that she considers that they are the stepchild or the bastard child of this system. Despite that sentiment, I want to take the opportunity to publicly acknowledge that the members of the Bar Association are very grateful for the work of the magistracy. And in the aftermath of hurricane, whilst others were forced in certain instances to flee, I know that the members of the magistracy remained, and I saw them in their T-shirts and their shorts trudging through the streets as we all were, and they demonstrated their commitment to the maintenance of justice in this jurisdiction. And for that, we, the members of the Bar Association, are grateful. My lords, I thank you.
An important lesson for all of us. We have an uncanny ability as human beings to survive and thrive, even in the most adverse of circumstances. We need to acknowledge the courage, resilience, strength of character, and mental toughness of the people who reside in this territory. We need to applaud this, recognizing what it says about our capacity to deal with loss, suffering, disappointment, and yet rise up each day
and get on with it. But we must recognize that we could not do so without the goodwill and assistance of family, friends, neighbors, and well-wishers. And we must also recognize that none of this would be possible without the grace of God and His boundless mercies. We have a lot to be grateful for. This was brought home in the days following the passage of Hurricane Irma and Maria in September of last year, when the court was up and running days after the storm. For that, we have to thank the Honorable Chief Justice, who worked diligently to ensure that the wheels of justice continue to churn in the BVI. I personally witnessed her cracking every whip to get the court relocated and open for business. We echo the Honorable Chief Justices in her thanks to the Government of St. Lucia and the Chief Registrar and the staff of the Eastern Caribbean Supreme Court headquarters, who in the space of one weekend created and provided a suitable location, equipment, materials, and staff for the court, as well as accommodation, transportation, and all the expected amenities for the judges. We thank the government of the BVI for its unwavering support to the court, which enabled the resumption of operations in the BVI in January of this year. We also have to thank the registrar and the staff here in the BVI who put their individual shoulders to the wheel at no little sacrifice. Deputy Registrar Nonnie Georges, for example, had to relocate to St. Lucia shortly after the storms, leaving behind her family, including her ill and aged parents. We can only imagine the personal cost to her. Sadly, we will lose Ms. Georges at the end of this month, and we would like to take this opportunity to publicly thank her for her sterling service to this court and to this territory. We must also acknowledge the magistrates, the honorable magistrates, who continue to discharge their duties admirably. In the wake of the storm, they remained in the BVI, working to restore the court and the functioning Supreme Court, summary court jurisdiction. I would like to pause here to express our appreciation and to welcome the new judicial officers of the summary court. Her Honor Giselle Jackman Lumi, who I believe is in court here, let me take this opportunity to recognize your presence. Her Honor Crystalline Benjamin, His Honor Hakeem Creaky, and His Honor Jack Husbands. They assumed duties in August, and I believe they are making an invaluable contribution already. I would also like to welcome His Honor Sean Innocent, who joined the court on the 3rd of September, replacing Mr. Hakeem Creaky, who demitted office in order to take up advanced studies. We are grateful for Mr. Creaky's willingness to serve. We must also acknowledge you, the members of the BVI Bar, those of you who contributed to the recovery efforts, be it financially, or with your time, or with your effort. Your continued patience and forbearance has not gone unnoticed by this bench. This last year has hopefully demonstrated to us, if there was ever any doubt, that our justice system and the rule of law are important and indispensable pillars in this society. They are in many ways fundamental contributors to our economy and therefore our way of life. We are pleased with the role played by the BVI Bar Association in the last year. They played an invaluable role in keeping us informed of all the developments and other important information. We are heartened that the new president of the bar and her executive have taken positive steps to foster that sense of fraternity, and we look forward to participating in the upcoming seminar, Becoming a More Effective Advocate, later in November of this year. There is, however, much that can be improved. It is 2018, and we still have not managed to have the laws of this territory available electronically. The adverse impact which this presents was reinforced during the period when the court was in diaspora and had no access to the laws of this territory. I am therefore forced to again call for this to be addressed as a matter of priority, not only for the judiciary and the members of the legal profession, but for all members of the public who have the right to access the laws which govern them. If we are to fully engage in the e-filing project, which will soon descend on us, from what I understand, it is due to be deployed later on this year. It seems wholly inconsistent that we have to be hamstrung with the hard copies of the laws which are to be applied. Additionally, I'm obliged to point out that our law library, which was once the envy of the Eastern Caribbean courts, was completely destroyed in the storms and will have to be replaced either through donation and direct purchases. I understand that work on that has already begun, and so we expect that that will soon be rectified. We are pleased to note that the criminal division has returned to its home. However, while the physical structure of the court appears to be back to normal, there are still issues that need to be rectified. There are minor issues with respect to the jury room, the judges' chambers, the main courtroom. There are electrical and air conditioning matters that need to be addressed. However, the users of this building are thankful for the progress that have been made by the contractor and the registry staff. With regard to matters that are awaiting trial, it is hoped that the witnesses will be located and those who wish to return to the territory will do so if they have not already. Finally, we recognize that effective communication is key to an effective and efficient criminal justice system. If all parties engage in meaningful communication, then many of the delays experienced last term will not be encountered this term. Justice Smith has prescribed that where protocols and procedures need to be drafted and put in place to lessen the backlog, these will be implemented, and we will expect the full cooperation and collaboration of both the prosecution and the defense bar in seeing that these initiatives take root and succeed. The commercial division is equally challenged in varying degrees. The commercial division returned to its home at the Commercial Court building in Road Town on the 19th of June 2018. And this was after the relocation to St. Lucia and the short relocation to the International Arbitration Center at Ritter House. This displacement was, of course, the result of the storms. Although the staff have moved in, however, external and internal repairs and refurnishing still continue. It is hoped that these will be completed soon. Nevertheless, the Commercial Court and its staff continued throughout the crises to operate at an internationally competitive standard, dealing with complex matters of high value and delivering decisions in a timely manner. This was possible by use of audio and video link and e-filing. The court continued and continues to be responsive to genuine certificates of urgency, hearing matters at non-standard hours, days and nights, where in the opinion of the court the exigency exists. To maintain a world standard as an international commercial court, it is necessary to constantly review the level of performance of staff, the compliance of the members of the bar with the rules and practice directions, and generally to determine whether there needs to be any adjustment to make the processes more effective, more efficient, and more fair. This requires the input of representatives of all stakeholders, and to this end, this term, the commercial court users, headed by the presiding judge, Justice Adderley, will be reactivated. As with all the divisions, the civil court was also significantly impacted by the storms. The court was also temporarily relocated to St. Lucia, but we managed to set up systems to deal first with urgent matters, and thereafter, we were able to convene regular sittings to try to deal with the emerging backlog of chamber matters. Since returning to the BVI, we have been housed at the first floor of the SACAL building. The current accommodation continues to be a challenge because it simply was not configured for court proceedings. Also, we do not currently have a courtroom dedicated for the Master's Court, and so he has been forced to squeeze in with the registrar's already cramped office. Nevertheless, we have managed to make significant headway into the backlog of trial matters created by the storms. With regard to the civil and master's courtrooms, I understand that although work is still ongoing on the 3rd and 4th floors of the SACAL building, which are intended to house the registry and the courts, it will not be available until the end of this year. So we will ask for the continued forbearance of not only the bar, but members of the public who use these courts.